Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Our discussion today will be on the next type of equitable remedies: rectification, rescission, cancellation, and declaration. So this is the last part of our lecture for this semester. Okay. We will look into the remedies. All of these remedies are provided under the Specific Relief Act. It has been legislated or codified in the Specific Relief Act. Therefore, in terms of the requirement and establishing the remedies, it has to follow the provision under the SRA. Okay, let's go first with rectification. So as you know, equitable remedy is in its nature is discretionary, meaning that it depends on the judge's conscience or discretion to award or to grant the remedy. So for rectification, basically the remedies is applied by the parties or is sought by the parties when an instrument failed to express the intention of the parties. So basically, if you have a contract, the contract must reflect the intention of the parties, right? So if the wording of the contract, especially the express wording of the contract, does not reflect the intention of the parties, so it can be rectified or corrected. According to Snell's, a famous author in equity, he mentions that he described the meaning of rectification. So rectification is a written instrument that does not accord the true agreement between the parties. Equity has the power to reform or rectify that instrument so as to make it accord with the true agreement. What is rectified is not a mistake in the transaction itself, but a mistake in which the transaction has been expressed in writing. So the reason why rectification is sought for is because of the mistakes or the inclarity, the vagueness in the agreement. So this remedy allows the party to rectify the wording or the terms of the agreement to make sure that it shows or demonstrates the intention of the contracting parties. So there are several situations or scenarios where rectification may occur. Number one, when there is accidental inclusion of a term, meaning that there is unnecessary or not related terms to the contract. Number two, when there is accidental omission of the term, meaning that there is unintentional omission of the terms of the contract. Or it could be also other errors or absurdity which can goes to the, or it can affect the fundamental operation of the contract. And for rectification, this remedies is only applicable for or in the context of written agreement. Under the Specific Relief Act, Section 30 explains on the situation when an instrument may be rectified. In this section, basically there are possible scenarios or situations. Number one is due to fraud, and number two, due to mutual mistakes of the parties. Under this section, it says that a contract or other instrument in writing does not truly express their intention. Either party or his representative interest may institute a suit to have the instrument rectified. And if the court finds it clearly proved that there has been fraud or mistake in framing the instrument and ascertain the real intention of the parties in executing the same, the court may, in its discretion, rectify the instrument so as to express that intention, so far as this can be done without prejudice to rights acquired by third parties in good faith and for value. So there are a few things that we can derive from this section. Number one, in rectification can be done when the content or the wording of the agreement does not express the intention of the parties. It could be the parties or his representative. For instance, in the case of trust, where the settlor has passed away, then the trustee can have the power of attorney to rectify the instrument. The reason, number two, the reason for the rectification is either because of fraud or mistake in drafting the contract or instrument. Number three, the court may rectify the document in its own discretion, meaning that when looking into the document, the court found that there was element of fraud or mutual mistake of the parties. The court can rectify the document. But it must not be done without prejudice to the rights of third party in good faith or for value. This could be the example of bona fide purchaser. For instance, there is already a trust created in favor of beneficiary. Okay, but due to some mistakes or accidental inclusion or omission of the term, there was some disagreement, or there was some misunderstanding about the contract. And before that happened, the land or the property has been conveyed to a third party who is a bona fide purchaser. In that situation, the document can be rectified, but it shall not affect the right of a bona fide purchaser who does not know in good faith that there is a mistake or there is a fraud in the contract, in the earlier contract, I mean in the trust. Here, what the court rectify is the instrument to make sure that it reflects the intention of the parties. The court does not rectify the contract as a whole, but the court look at the specific terms and conditions of the agreement which does not reflect the intention of the parties. So mistake here is a common issue, especially when it comes to drafting a contract. In the case of Lim Hong Shin and Leong Fong Yu, this is an old case where the court held in this case the mistake must be common to all parties. So when this condition exists, the court may rectify the instrument so as to express the real intention, so far as this can be done without prejudice to right acquired by third parties in good faith and for value. Basically, this is taken from the section. So a party who signed an agreement with knowledge that it does not reflect a prior common understanding will not be eligible for rectification, meaning that if the parties is aware that at the time of signing there is already a mistake, but there was no rectification is done at that particular point of time, the remedy would not be applicable to them later. But this remedy is only applicable when the parties do not recognize or does not have knowledge about the mistakes in the terms of the agreement. In the case of Maralinga Property Limited and Major Enterprises Property Limited, in this case, the auctioneer read out the written terms prior to the auction, and that included the ability to pay the purchase price in installment. So between the hammer and the signing, the owner changed his mind about the terms. The purchaser was asked to sign the written agreement with terms different from those read out at the auction. So the change was made in between before the bid was finalized. He was unhappy, but he knew that the changes were not common among the parties. In this case, the rectification remedies is not available to the parties because the agreement has been read to them, and they are already aware of the change of the agreement, the terms of the agreement. Mistakes just now must be a common, must be common to the parties. Number two, mistake can also be unilateral mistakes, meaning that the mistake is done by one party but it's not known to the other party. So this can be a case of fraud. So in the case of fraud, you can, when it comes to the mistake in the terms of the agreement, it can be rectified. However, again, the fact that I mentioned to you just now, I reiterate that rectification is only possible if the other party is not aware of the mistake, meaning that it must not be intentional, it must be accidental. If it is intentional, then you would not be able to seek for this remedy. You're not qualified to apply for this remedy. In the case of Thomas Bates and Windhams Limited, the parties negotiated a new lease pursuant to renew clause contained in their original lease. The original lease contained a rent renew clause which allowed an arbitrator to settle the renter under the new lease. If the parties could not agree, but new lease was already executed, this clause was accidentally left out. So when they prepared the new lease, the lessee was not aware of the absence, was not aware of the new terms, but the lessee was aware about it. The arbitration clause, as they have agreed, is necessary, otherwise the agreement cannot be enforced. So when the time came to renew the lease, the lessee argued that the renew clause was not enforceable, but the court thinks that it is unfair to say that the contract cannot be enforced. Therefore, since the other party, the lessor here, was not aware, that is good enough to say that, and the lessee was aware, so that was a mistake by the lessee, but that was not known to the lessor. So unilateral mistake also can allow the case to be, or the terms of the contract to be rectified. Here, they miss out the new clause on the arbitration. So the accidental omission of the clause has entitled the party to rectify the new lease by including the arbitration clause. So the contract, in conclusion, can be rectified. All right, another element is that just now we're looking at the reason why rectification can be done is either by way of due to fraud or mistake. Another element from the session is the rectification can be sought when it does not truly express the intention of the parties. So here, you know that rectification can only be applied or can only be sought in the case of, or in the situation of, written agreement. So when you look at the agreement, you can understand that the agreement failed to reflect, failed to express the true intention, the true intention of the parties. So the parties who can apply for the rectification is the party who is not aware of the mistake or fraud. Okay. And next, under this section, it must be clearly proved, meaning that the person who seek for rectification remedy must clearly prove, basically in this case, it must be proof on the balance of probabilities, and you must provide that the mistake was done unintentionally or accidentally. So they must be supported with proof. Here you can support with evidence of the contract itself, where, for instance, you are not aware, okay, of the mistakes or fraud committed by another party, and the mistake or fraud is not known until you realize one day that it needs to be rectified. So the absence of knowledge or not knowing about the mistake is actually an evidence, but it has to be proven by the agreement and also according to the conducts of the parties in the contract. For instance, the other party who is aware of the mistake never inform or communicate about the mistake or omission in the terms of the contract. In the case of Zakaria Daud and Siti Hussein, Justice Kopasri Ramya said, when it comes to the case must be proven convincingly with convincing proof, the evidence should be cogent and must meet a very high standard of proof. The transaction entered into between the parties and the documents executed between them voluntarily and for value and valuable consideration are not to be set aside by willy-nilly for the slightest reason. Were it otherwise, the law would be riddled with uncertainty and commerce will come to a standstill. So if the parties has already good faith in performing the contract and the mistake is not known to another party, then it shall not, the judge say, frustrate the contract. It does not mean that the contract cannot be enforced, but you just need to rectify the mistaken terms in the agreement. Please read the case for the details. Next, it must also not cause prejudice to rights acquired by third party in good faith and for value. So this is quite valid, particularly as I mentioned to you just now, when there is rectification order, it shall not affect the right of the bona fide purchaser without notice or for value. Right, next, the remedy that we're going to discuss is rescission. Rescission is a right to repudiate or set aside a voidable contract. So you know that there are many reasons why you can have the option to terminate a contract. Rescission is one of them, particularly according to Hambury and Martin. Equity allows rescission to aside a valid contract at common law, especially when there is a voidable element of contract like fraud, mistake, undue influence, right? And the effect of equity also can take effect by ordering account or inquiries, meaning that when you have this remedy, you can allow the party to recover the profit or to deliver up the losses to the aggrieved party, to the victim. And equity here can also grant relief on terms, meaning that it can grant relief according to the terms of the contract. So these are the more specific way of enforcing the order of rescission, which may exist in either forms below. For instance, in the case of constructive trust, where the trustee has breached the obligation as a trustee to take care of the property in favor of the beneficiary, or in that situation, the trustee has represented or misrepresented himself as the owner of the property to a third party, but by way of fraud, the property has been sold to a third party, and the third party is a bona fide purchaser. In that case, rescission remedy can be sought by the parties. Right. For the other example, rescission itself or reformation, accounting for profits or ejectment and reply vin. Okay, let's take the example of accounting for profit. If a trustee has already made money out of the sale of the land to a third party by way of fraud or other reasons of voidable contract, rescission can be sought. And apart from that, it could also happen in the case of equitable lien and quasi-contract. So the goal and purpose of restitutionary remedy is to prevent the defendant's unjust enrichment by defendants give back that which the defendant had wrongly or unjustly gained at the plaintiff's expense. this could be a case of restitution where you need to restore the case to its or the contract to its or the obligation, the right of the plaintiff to its original position. Section 34 of the Specific Relief Act discusses on or explains on when rescission may be granted. Number one, you must prove that there must be a voidable contract, or there could also be possible in the case of unlawful contract for causes that apparent on its face and the defendant is more to blame than the plaintiff, or in the case of a decree or order for specific performance in the case of sale and purchase, contract of sale, lease and default of payment. So for voidable contract, it's quite clear, isn't it? You can refer to the Contract Act. For unlawful contract, so when you look at the parties, the defendant is more to blame because he fails to inform the parties about the, for instance, actual possession of the land. In the case of adverse possession of the land, for instance, the defendant is to be blamed because the defendant failed to inform the plaintiff on the adverse possession of the land. Number three is on the case of specific performance. For instance, when the property is sold to a third party, but it is not represented truly or honestly by the plaintiff. Or it could also be in the case of default of payment. You can take the example of, for instance, money lending transaction, okay, where the transaction is not registered, but because of the default of payment, so the parties can take action under rescission to terminate the contract. The other situation also is where the wrongful possession or of subject matter is arise, where there is a wrongful possession of the subject matter. So, for instance, the landlord has taken several property of the tenant. In that case, the wrongful possession of the subject matter, the tenant can take action under rescission. Rescission for mistakes, section 35, is applicable for contract in writing and to restore the right to substantially the same position as if the contract has not been made. So this is somehow related to restitution. For instance, assume that a person built a barn on the property of another person and assume further that the structure is not built according to the contract or agreement, and the owner of the property refuses to pay the builder for the barn. So despite there is no contract, the court can order the owner to pay the builder the cost of the labor and material under the doctrine of restitution. So here, the owner can recover the property, but he must pay the cost which has been incurred by the person who has built a barn on his property, because the person does not have knowledge about it, and that was a mistake actually. So the contract, the action can be taken by way of rescission, even though there was no contract between the owner and also the builder. Right. Rescission can be an alternative remedy as well, beside the specific performance, section 36. If a contract cannot be specifically enforced under section 11 of the SRA, the plaintiff may seek alternative remedy. That means if the specific enforcement cannot be available for the plaintiff may go for rescission. It's not like beside the specific performance. This is to substitute specific performance with rescission. So for that reason, the effect is that the contract will be terminated, the contract will be rescinded and delivered up to be cancelled, meaning that the parties will be going back to its original position. For this reason, where there is a rescission, the parties can apply can seek for compensation under Section 37 in the case where specific performance is not granted. Right, the next remedy is cancellation. Cancellation is cancellation of the written instrument. So differently from rectification, rectification is actually rectification of the terms in the instrument. It does not change the validity of the instrument. But for cancellation, that will affect the validity or the existence of the written instrument. So for this part, an equitable remedy by which a court relieves both parties to a legal document and their obligation under it. And this cancellation, if you look at the reason why cancellation is allowed, is due to the reasons of voidable and void contract. Fraud, duress, and mistake, those are all under voidable contract. For mental incapacity, that is a case or that is a reason under void contract. So for cancellation, it may occur in the case any instrument by which two or more parties agree to exchange designated performance, such a contract, deed, lease, insurance policy, or a mortgage. It may be cancelled in the case of fraud, duress, mistake, mental issue, etc., etc. Section 38, subsection 1. So it is possible just now, as we discussed, possible in the case of void and voidable contract. And there is reasonable apprehension that the instrument has caused serious injury to the aggrieved party. So if the instrument has been registered under any law in force, meaning that if you enter into a contract, you register, you sign and say it become a legal rather than equitable, the court shall send a copy of its decree to the office in charge of registering the instrument and note about the cancellation. In some cases, not all parts of the instrument may be cancelled. It can be partially cancelled as well under Section 39. Where instrument is evidence of different rights and obligation, the court may cancel in part and allow it to stand for the residue. Please have a look at the illustration for understanding. The court, in the case of cancellation, may require the party to cancel the instrument and to pay compensation under Section 40. The next remedy is declaration. Declaration is a statement from the court setting forth the rights of the parties. So declaration is more like the court declaration to declare, to make declaration over the right and obligation of the parties. So here we refer to Section 41, where declaration is actually a court. It depends on the court discretion to declare on the status and rights of the parties. Please have a look at the illustration. Section 42 discuss on the effect of declaration. If there is an appointment of receiver where the company is under receivership, the court will put the trial on hold, and it all depends on the courts to decide on the declaration. That's all for this topic. Have a good day and thank you. Assalamualaikum warahmatullahi taala wabarakatuh.